All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you, Madam Clerk. Good afternoon and welcome to the Court of Appeals. Your panel this afternoon is to my right, Judge Murphy by phone, and to my left, Judge Jeff Carpenter. My name is John Tyson. I notice a very full courtroom today and would like to welcome the many interns and students that are with us today that are helping us this summer at the court. We have two cases on the docket today for oral argument. Matta versus North Carolina Department of Transportation and Wonder Day Partnership versus North Carolina Department of Transportation. These cases have been joined for oral argument by order of the court. And gentlemen, I wanted to ask, ladies, if there's some division that you would like to share with the court as far as your time is concerned.
My understanding, Your Honor, is that each side will be given 30 minutes. The appellant will reserve 5 minutes for rebuttal.
Okay.
That's my understanding as well, and I, as the appellee, will not be reserving any time, of course.
Right. So I'm going to let you manage your own time if there are multiple members of the bar that would like to address the court, so that will be within your discretion if you choose to do that, okay? And we'll reserve 5 minutes for rebuttal. Are there any other preliminary matters to come before the court before we get started?
No, Your Honor.
Okay, hearing none, we will hear from the appellant. Good afternoon.
Good afternoon, Your Honor. May it please the court.
Let me verify one thing.
Yes.
I want to make sure Judge Murphy, can you hear us and are you with us?
I can hear you and I can hear counsel fine. Can everybody hear me okay?
Yes, yes, we can. Thank you.
All right, thank you.
Thank you, Your Honor. May it please the court, I am Howard Rhodes of the Banks Law Firm for the Department of Transportation. The Supreme Court established the law of the MAP Act in Kirby and Chappell. DOT and over 700 landowners have lived by that law in settling and litigating cases since 2016, in which landowners were treated as having been subjected to a negative easement of indefinite duration, and the damages of that easement were measured from immediately before to immediately after the date of taking.
We're talking about a roughly 20-year span, is that correct?
The corridor maps were recorded in these cases in 1996. That's right, Your Honor, and the General Assembly rescinded the corridor maps in 2016. So that's the 20-year period. Now, the rescission of the corridor maps is a key issue in the discussion that will take place before the court today. The rescission of the corridor maps was irrelevant to the nature of the MAP Act taking and the measure of damages that applies to it.
Now, both these cases come to us from the Wake County Superior Court from Judge Collins, is that
Yes, sir.
correct? And he was designated by the Chief Justice to hear both of these cases by order?
He was.
So as far as we can tell, except for the identity of the parties, all the issues that are before us today are identical. Is that correct?
All of the issues, for both of these cases, that is correct, Your Honor. In both Matta and Wonder Day, the issues are exactly identical. The orders that were entered in each case, except for a small factual matter, mirror each other 100%.
So let me ask you this. Have there been MAP Act cases where there were certain landowners that were restricted by the MAP Act corridors that the DOT never purchased from them at all?
If a landowner was subject to corridor map restrictions but never filed a complaint in inverse condemnation, it is
That's
possible.
not my question. My question is, were there corridors that were subject to the MAP Act where there was no taking, no permanent taking as we have here?
Any property that was subjected to a corridor map was subject to a take.
Okay.
I'm still not sure I'm tracking your question, but
There was property owners that were subject to the corridor maps.
Yes.
Were there any property owners subject to those maps that the state didn't actually take the property, didn't buy the property from them, or take it and then pay just compensation? Was there land designated subject to the maps that was not,
that
did not
was
at some
not
point come to
ultimately
ownership?
subject to direct condemnation? Yes, I believe so in different counties as the highway plans shifted. There were certain property owners whose property had been subject to a corridor map, but subsequently the property wasn't needed for the purpose of the actual construction. And so in different counties, there are some landowners that would meet that description. Yes, Your Honor.
And their claims would be based upon the temporary deprivation, is that correct?
No, Your Honor. Their claims would still be based on Kirby and Chapel, which is that what they were subject to on the date of taking was the acquisition of a negative easement for an indeterminate or unlimited period of time. And that isn't changed. That basic fact under Kirby and Chapel isn't changed based on whether or when the department files a direct condemnation, whether or when the landowner applies for a variance and removes the restrictions from the property, or whether, on some date in the unknown future, the General Assembly rescinded the maps. And the reason that that's the case is because of the distinct nature of what the state did with the MAP Act in relation to landowners. And what the state did was fundamentally different than what it does with all temporary construction easements or all expressly temporary public health and safety regulations, such as the one at issue in First English. What the MAP Act does is give DOT the right to restrict properties for an unlimited period of time, where there is no suggestion that those restrictions are time-bound in any way. That's a fundamentally different act in relation to landowners than when the state comes in and says they will temporarily restrict your property for a construction easement, or they will temporarily restrict your property under a public health and safety regulation. The announcement up front to landowners of the temporary nature of a taking makes a profound difference to landowners in terms of their planning, in terms of their investment in their property. When the state reserves the right without question to restrict for an unlimited period of time, that undermines the position of landowners in a way that is fundamentally distinct. And that's why the Supreme Court, given its factual analysis of what the MAP Act actually does, makes the date of taking and what the state acquired the right to do the focus of the court's inquiry.
Now, if I remember the MAP Act correctly, there were provisions that allowed a landowner to petition for release from the restrictions. Is that correct?
That is correct, Your Honor.
And the DOT at that point would either have had to have released the property or purchased it.
That's correct.
So you don't like the, I guess they're taking issue with the characterization that the restrictions of the MAP Act for the 20 years were temporary. Is that correct?
That's correct.
And so tell us why, particularly in cases where there were corridors that were not purchased, why that would not be a temporary taking when the map was released.
In part, it's simply because that is precisely how the Supreme Court analyzed the issue and determined the nature of the taking in both Kirby and Chapel. In Chapel, the Supreme Court upheld the trial court's exclusion of DOT's evidence in that case based on the idea of a temporary easement, because the court said DOT's evidence was premised on the notion of a temporary easement that was because of the landowner's ability to remove the restrictions if it took an affirmative step. And the Chapel Court said, because it was premised on the idea of a temporary easement, it was properly excluded because this court has established as a matter of law that a MAP Act taking is for an indefinite duration. The Chapel Court addresses the issue directly and explicitly.
Now, in
So
this case,
even-
in
pardon
this
me.
case, if I'm not mistaken, I'm remembering the timeline. The legislature repealed the MAP Act. There was a suit brought by the plaintiffs under 40A or 136, one of the two,
136, yes, Your Honor.
to be compensated for the deprivation of use for that period of time.
That is correct.
And after that suit was initiated, the DOT, the Department of Transportation, then decided to permanently to file the instant action that's before us today. Is that correct?
No, Your Honor. The action that is before the court today is the appeal of the plaintiff's inverse condemnation claim.
But am I not correct that the DOT actually filed and took title to the property while the suit was pending by the plaintiffs?
It did in 2020 in a case that is not before this court, but is subject to a separate appeal in the Wonder Day Partnership case, so not in Mata. DOT did, in fact, do a direct condemnation to acquire the remainder of the fee. And that, just to readdress the factual issue you raised at the beginning, that is what has happened in the overwhelming majority of cases subject to corridor map restrictions, that there is, in fact, a subsequent direct condemnation.
So there were actually two actions. There was one by the plaintiff, and then the filing of the take by the DOT.
That's correct. And DOT filed a motion to consolidate those for a single hearing, which the trial court denied. But DOT's position was that it is important for the court, the trial court as well, frankly, as the Court of Appeals, to see the interrelation between the two takings and how they are both envisioned as a part of a common scheme under the MAP Act.
Let me ask you this. If I'm an owner of property and I decide to lease it to a tenant, and that lease or that arrangement would determine the respective parties' rights. Do you agree with that?
Yes.
Okay, and then sometime after the lease or during the lease, the tenant decided to buy the property.
Yes.
Would the tenant be entitled to any credit for the rent that was paid in the absence of an express agreement to credit any rent toward the purchase price?
In that scenario, no, but that scenario is not analogous to what happens under the MAP Act. Under the MAP Act, the state didn't take a lease. It acquired a negative easement. It was an acquisition, not a rental. And the Supreme Court made clear why. The first reason is because of the way in which the department's acquisition of the negative easement was part and parcel of a highway project. When it imposed the restrictions, it triggered simultaneously under the statute pre-engineering work on the highway project and environmental studies. The Kirby Court says you simply can't understand what the state's doing with these restrictions if you don't pay attention to the way in which it's also triggering the highway project work. Second, of course, is the anticipation of that subsequent condemnation, as Your Honor has noted, that in the vast majority of cases, the MAP Act restrictions don't so much end as they are subsumed into a future acquisition of the entire fee.
Now, in the briefing, it was noted that once the MAP Act was repealed, that the property owner was no longer subject to restriction. Is that correct?
That is correct.
So it was the property, if it did not affect it from that point going forward.
That is correct.
But your argument, as I understand it, is you want to tie both together. If there was a taking, then it relates back to the original MAP Act. But if there's not a separate permanent taking, then the damages are limited to the quote negative easement as you frame it. Is that correct?
I don't believe so, Your Honor. Under Kirby and Chappell, the Supreme Court has said the Department of Transportation must pay just compensation to all landowners subjected to corridor map restrictions for a negative easement of indefinite duration as measured by the value of which is measured from the change in fair market value from immediately before to immediately after the date of taking. That's what the state has to pay for, period, regardless of whether they step in later and either rescind the corridor map restrictions or condemn the property. That's what the Kirby court says the state must pay for. When the
But that's
state,
a lesser amount than the state would pay to take actual title.
to
You
take
you
action-
value easements differently than you do fees, correct?
That's right. So what the state must pay for under the MAP Act taking is the taking of 3 sticks from the bundle of rights. And they pay for those 3 sticks for an unlimited duration plus interest from the date of taking until the date of final judgment. When the state steps in to acquire the remainder of the fee, all the rest of the sticks in the bundle, they don't repay the landowner for the 3 rights the department has already paid for, or that would be a double recovery. So what the department has to pay for in the direct condemnation is the value of the remaining rights as of the date of the acquisition here in 2020. Now, this court in NCDOT v. Stimpson recognized the interrelation between the 2 takings in just that way. In Stimpson, the court recognized that if the trial court were to determine that DOT owed just compensation for the entire fee on a given property under the MAP Act, there would be nothing left for the department to acquire by direct condemnation. In Chappell, the Supreme Court recognized a similar interrelation between the value of the MAP Act taking and the value of the property for the subsequent condemnation. And there, the Supreme Court said, essentially, that the value paid for the rights acquired under the MAP Act would essentially set the value of the property when it comes to the direct condemnation. And so the position of the department here in these appeals, which, of course, I mean, part of the confusion here is that this is an appeal of the MAP Act claim. There is a separate appeal of the direct condemnation because the cases weren't consolidated. But the trial court's orders here go ahead and they speak to 2020 CVS cases that are not before the court. Nevertheless, the relation between the 2 is that the department is required under Kirby and Chappell to pay landowners, all landowners, these and everyone else, for a taking of indefinite duration as of the date of taking. They don't then repay for those same rights when they acquire the remainder of the sticks in the bundle. Otherwise, that's a double recovery. The landowners here try to evade that by construing the MAP Act taking as a leasehold. Precisely the example that Your Honor provides. If you just lease it and then you terminate the lease and then you want to buy, you don't get credit for the lease. But this never was a lease. And that actually points to precisely why the Supreme Court determined the rescission is irrelevant. The rescission is irrelevant because what doesn't happen is that after restricting property for 20 years, when you remove them, it not only sets a term, somehow it transforms the nature of the original taking. I mean, there's no basis in law. First English certainly doesn't stand for that. The issue in First English was that there was an expressly temporary public health and safety ordinance that was imposed on the landowner's property.
Do you agree there's a difference between an inverse condemnation and a condemnation where title is actually transferred to the state?
I would need a bit more clarification, but I will say no in the sense that when a landowner brings an inverse condemnation claim, it compels the state to exercise eminent domain, and that may involve, but may not involve, the transfer of title.
Well, isn't it like actually imposing a servitude or use on another's property without compensation? That's what the inverse condemnation is.
That is true.
So, like flooding from a pipe,
That's right.
putting water, that's an inverse condemnation claim, because title did not transfer. So help me understand how an inverse condemnation claim, where there's a use of property by an entity with the power of condemnation, how that necessarily melds into where a permanent taking is made where title is transferred.
Okay. As Kirby and Chappell both establish, what the department acquires by recording a corridor map is the taking of 3 sticks from the bundle for an unlimited period of time. The way that then flows into a subsequent direct condemnation is that in the direct condemnation, the department's obligation is to require the remaining sticks. It will already compensate the landowner for the original taking plus interest at the statutory rate from the date of taking until the date of final judgment for those 3 sticks that were subject to the MAP Act.
What are the 3 sticks? You keep referring to the 3 sticks. What are the 3 sticks?
I apologize. The 3 sticks that the MAP Act statute acquires is the landowner's rights to improve, develop, or subdivide their property. As the Chappell decision recognized, the landowner, subject to a MAP Act, corridor map, retains
Give me the 3 again. Improve?
improve, develop, subdivide.
Okay.
The landowner retains all rights to do as they wish with their property as long as it doesn't require a building permit or a subdivision plat. That's what the Supreme Court in Chappell recognized. The Chappells of the Chappell decision, they lived in a house subject to the corridor for 20 years while the restrictions were operative.
Well, the DOT had argued in Kirby that what they were doing was police power and not an exercise of eminent domain. This court disagreed with that analysis.
Absolutely, and DOT squarely lost that argument before the Supreme Court in Kirby, where the Supreme Court said that it was an exercise of eminent domain that caused an acquisition, not a regulation. Now, why, I believe, is essential. A regulatory taking would require the landowner to show that they had lost all economically beneficial and productive uses of their property. If that was the hurdle, the Chappells of the Chappell decision would never have even had a claim for compensation because it wasn't a regulation. The state has much wider latitude in imposing public health and safety regulations on landowners than it does exercising eminent domain and acquiring rights. Kirby treated all landowners equally by saying they were all subject to an eminent domain acquisition, and no landowner had to come forward and show that they had been subjected to a regulatory taking, because the court understood most MAP Act landowners would not be able to make that showing. I mean, that's just brass tacks, factual stuff on the ground. That's not the law. I mean, Kirby also just points out the MAP Act restrictions have nothing to do with public health, safety, or welfare. They're tied up with a highway project. So it's not a police power regulation, but why that matters is because of the evidentiary hurdle that landowners would have to clear in order to have a claim for compensation at all. Kirby takes that off the table. These landowners are attempting to get credit for a regulatory taking without either them or the trial court making any findings of fact that the MAP Act taking qualifies as a regulatory taking, but they want the benefit of a different measure of damages, one that is different in kind, that has been applied in over 700 MAP Act cases that have gone before the courts and either been litigated or settled.
Let me ask you this. Generally, on a regulatory taking or deprivation of use, the loss in those cases is different than when a physical taking title transfers. Do you agree with that?
It can be. I think it gets complicated quickly, but it certainly can be.
Generally, if title transfers, the value that the property owner is entitled to is generally highest and best use. Do you agree with that?
In all cases, it's highest and best use.
Would that same measure of damages be applicable to an inverse condemnation?
Yes,
So it's
as
not,
of the date of taking.
so it would not be present use, the value of the present use or the deprivation of use. You're saying that if they could build the skyscraper there on a patch of wooded land, that's the use they would get on an inverse condemnation.
The MAP Act inverse condemnation claims are the value of the damages is measured on the date of taking. So the appraiser in any of those cases has to stand in the shoes of the property owner on the date of taking and evaluate the highest and best use on that date and all other relevant facts on that date to determine the change immediately before to immediately after.
So you're saying there's no value attached to the ownership of the property in terms of damages, is that correct? It's the same damage, whether you own the property or you don't, whether you have the right to use it or you don't.
That, I'm not sure Your Honor's point. That does not sound like what I am saying, though.
Well, that's the reason I want to clarify, because they would not necessarily, for deprivation of use under an inverse condemnation claim, highest and best use damages would not necessarily be what the property owner would be entitled to.
On the
Whereas
date,
where title transfers and they lose their property, then the damages there would be highest and best use.
my time is up, but I will answer that question. On the date of, for a MAP Act inverse condemnation claim, the landowner is entitled to damages based on the highest and best use of their property as that changes from immediately before to immediately after the taking.
Thank you. Hear from the appellee.
Your Honor. Good afternoon. May it please the court. I'm Stephanie Autry. I'm here with George Autry and Jeremy Hopkins. We are proud to represent Elizabeth Mata and the Mata Family LLC and Wonder Day Limited Partnership. Both of those clients, both of those property owners owned large vacant tracts of land in Wake County. I'm going to mostly address Mata, just for simplicity, though the arguments apply to both. Let me say first of all that I'm glad that Mr. Rhodes has admitted to this court that what the DOT is doing is trying to get a condemnation discount. You know, what it's hard for me to listen to him say is that they deserve a discount or a credit for money that they haven't paid, money that they owed 28 years ago. Ms. Mata.
Let me ask this question. I want to clarify for just a second how I was interpreting the state's argument, and maybe this is kind of what you're hinting at here too, is that let's pretend that in 1995 I owned some property in Wake County, and MAP Act came. I wasn't doing anything. I didn't really care. None of that mattered to me. I'm not litigious in 2017 when the MAP Act gets repealed and I have these rights, and maybe I've slept on them for the last 8 years, and now the state wants to come in and take my property and take the entire fee. Is the state arguing that they would not have to compensate me for that portion that would have been covered by the indefinite taking now when they're taking the entirety of the fee?
What they're saying, Your Honor, is that they would not have to compensate you in 2017 or 2020, as was the case for the direct takings here, based on the unrestricted value of your property in 2017. That instead, they could employ the fiction that the MAP Act freezing of your property, which occurred in 1996, maybe it didn't do you any harm, but it froze your property for all those years, that encumbrance still continued in 2017. And they could treat your property as though you could still live in it in your brick ranch, but let's say that it was, like Ms. Mata's property, a 100-acre tract. You couldn't build anything else on it but that brick ranch. You couldn't subdivide it. You couldn't get a site plan approved. So what that means is when they came along to actually take your property to build the road, they would be paying you based on a price as though you could not develop your property, although in fact the restrictions had been rescinded in 2016. And I'm sorry if I did not answer your question.
No, I think it does. And that's what I was a little bit worried that I was hearing from the state. So thank you for clarifying at least your perspective on that. Thank you.
I'm worried that I'm hearing it as well. You know, as Judge Collins said, and remember, he was hearing these cases as the Rule 2.1 judge. He was requested by the DOT to be their judge because of his experience with MAP Act cases and with direct condemnation cases. His order basically reads like, I cannot believe this. I have never seen anything like this in my life. And he hadn't ever seen anything like it in his life. He had presided over scores of direct cases of properties that had formerly been encumbered by the MAP Act, and DOT had never tried to take this position before. So,
Would this be would they have the same position if, say, I inherited the property last year that, you know, my parents left on their MAP Act rights, and now we're going to come in and condemn, and yeah, we're going to do it under this new valuation, or even if I was a good faith purchase for value? Is the DOT saying this retroactive application of losing these basic development rights affect to all future purchasers?
that's a great question, and you know, there's only two possible answers, and they're both just terrible. One is that, let's say Ms. Mata held on to her property through all the decades that it was frozen. After 2016, when the restrictions were lifted and stricken from the public record, she was finally able to sell to Mr. Rhodes. Mr. Rhodes would come along and he would pay her the unrestricted value because the restrictions, in fact, didn't exist. There would have been no evidence of those restrictions in the public record. Ms. Mata would have very reasonably insisted on a purchase price that was based on the unrestricted value of the property, and Mr. Rhodes would pay that. Now, when the DOT actually came along and needed to take some of Mr. Rhodes' now property in 2020 for the direct action, there are two choices. Mr. Rhodes can either be shortchanged by the DOT because the DOT says, I'm sorry, you bought property that was restricted a long time ago, and we're sorry that there was not any notice to you in the public record, but that's the unique nature of this indefinite easement that existed in this case, and therefore this innocent purchaser without knowledge is deprived of just compensation of what he actually paid for the property. The other possibility is that the DOT realizes that it would be a violation of due process and unconstitutional to take Mr. Rhodes' property without paying him the full value because he didn't have any notice of these allegedly indefinite restrictions. The effect of that would be that the DOT would pay Mr. Rhodes a different price than it would have paid Ms. Mata if she kept the property. Now, that can't be right.
Let me ask you this, Ms. Autry, and this may be a factual question that has not yet been answered. was the taking, what the DOT actually took title to, was it identical to the same property of your clients that was restricted by the lines on the MAP Act, or do you know?
It's not exactly the same. The MAP Act corridor, the Mata property is about 100 acres, and it's a long property with a lot of frontage on Sunset Lake Road. The MAP Act corridor showed that all of the Sunset Lake Road frontage and about another 10 or 12 acres were encumbered by the MAP Act. The direct taking takes most of that property, but not all of it. And of course, the direct taking also has other impacts because it restricts access, for example.
So are you filing a different claim for your client's property that was subject to the MAP Act and that was not taken, as opposed to the property that they actually took title to?
No, Your Honor, because at the time, the DOT's property, the DOT actually took the property to build the road. The MAP Act restrictions were over, like a lease.
So did your client assert the claim for the restrictions on the property that was not taken?
We filed an inverse condemnation seeking compensation for the freezing of the land within the MAP Act corridor and for any damages to the remaining property using the measure of damages in 136-112, which is, it's the difference of the entire property, difference in value of the entire property before the taking and after the taking. It doesn't matter whether it's an inverse condemnation or a direct condemnation that physically gives the DOT the right to possess property. Once there's a finding that there's a taking, the same rules apply according to the United States Supreme Court in determining the duration of the taking and the measure of damages.
So the residual property, there's still property your client has that was not taken?
Correct.
So that's a different factor on what impact these takings, whether through the MAP Act or through the taking, through the physical transfer of the title, on the impact that would have on your residual property that you retain?
No, I don't think so, Your Honor, if I understand your question, because in either case, whether we're talking about land that was actually taken in the direct action or land that was just the remainder, which may or may not have been damaged by the direct taking, in any case, both of those pieces, parts of Ms. Mata's property, were free and clear of the MAP Act restrictions as of the date of the actual direct taking.
So you never, did you have that value appraised?
We are working on it. We're looking for guidance from the court.
So that has not been done at this time then?
That's correct, Your Honor.
So in your claim, under your inverse condemnation claim that you filed prior to the physical taking of title, what did you allege in your complaint as far as the measure of damages your client was entitled to?
You know, I haven't actually looked at that in a while, but I would believe that what we alleged was that, I know that we alleged that this was a temporary taking and that the MAP Act taking ended when the MAP Act restrictions were rescinded.
Let me ask it this way. Do you agree or disagree that a MAP Act taking claim alone would yield less damages to a property owner than an actual taking of the full title?
If I understand your question, then the answer would be yes, because the measure of damages for the MAP Act taking would be, the measure of damages would be the same, but the facts would be different. And here's what I mean by that.
Well, one would be the ownership of the parcel.
Correct.
And also the right of use. You know, once title transfers, then you have no rights of use.
Exactly.
Whereas on the MAP Act, you would have had rights of use. Is that correct?
I could not have said it better, and that is what the federal regulations in the yellow book say about how temporary inverse condemnation takings are to be valued. just like the MAP Act takings. What you have is you have, let's say somebody's living in their little brick ranch, okay? And that's the before use, okay? That's the unrestricted use. Let's say they could, they have excess land and they could have built something else, but for the MAP Act restrictions. That's the before use. It's the use before the restrictions, okay? So it was not zero, it was more than zero. In the after condition, we're talking about the difference in the before and after value of the property. The after condition is where the MAP Act restrictions have been imposed.
So we value easement takings differently than we value fee takings, is that correct?
You look at the rights that, that obtain to the property owner under the easement. If you look, for example, the DOT has relied on the State Highway Commission versus Black, which was a case where the DOT took an easement, but the land that it took as an easement, it actually built the road on, and it was never going to go away. They said it was perpetual. And what the court said, the Supreme Court said in that case was, it was a total and complete occupation of all of that land within the easement area to the complete and total exclusion of the landowner. That easement is different than a MAP Act easement, which did allow some uses to continue for the property owners, the current uses.
So your claim is the measure of damages would be different
It would be different because the
between an
facts would be
easement and
different.
a physical take?
Because the facts would be different. In a MAP Act situation, there was always an existing use that is still allowed. And there's always an after use that is still allowed.
So if a utility comes and takes a sewer easement across a piece of property, the damages are generally the diminution in value of that sewer easement, correct?
Under Chapter 40A, that's correct, Your Honor, because under Chapter 40A, you can either have the diminution in value or the difference in the before and after.
Okay. Whereas when title transfers, you are deprived of any residual use to the property whatsoever.
That's correct.
So going back to the damages your client would be entitled to, if you are entitled to damages for the MAP Act that are separate and apart from the transfer of the deed. You with me so far?
I think so.
How would you value your deprivation of use during the MAP Act as opposed to losing title in any use whatsoever of your property?
Well, I would have to say that the MAP Act taking would be a lesser taking.
So it'd be a diminution in value as opposed to a highest and best use?
I would not necessarily agree with that. I would say that you would look, under the MAP Act, you would look at,
If you got a highest and best use, you would lost title, you would have no residual rights to the property, correct?
if you lost title, then you would have no residual.
Whereas on the MAP Act, you would have use of the property subject to the burden of the restriction.
That's correct.
So that's the difference, is it not?
Yes, it is. Yes, Your Honor.
So
I think
you would be paid less for a burden than you would a total loss.
Yes, I think I see where you're going.
Is that a fair assessment?
Yes, sir.
So when you're appraising these, the credit, if anything, that would be entitled to a deprivation of use would be less than highest and best use if you lost the entire property.
That's correct. Because, yes, that's correct, because you would still have some remaining use, and that you would be measuring it by the difference before and after.
So if you applied the same measure of damages to either one, there'd be no value to the ownership of the property and whatever residual use would be through owning the property.
I'm sorry, maybe I'm obtuse, but I just do not understand your question.
My question is this, that if you own a piece of property, have some use of it, that has value.
Correct.
Whatever is diminished by that, you're damaged by what that is diminished by.
Yes, sir.
Whereas if they take all your property, then you have nothing remaining. You have no use and no value other than what you're paid when you're deprived of the ownership of your property.
Correct.
That's what I'm trying to say.
Yes, sir. I'm sorry. Yes.
So in terms of a diminished value, diminution in value, and whatever damage it would do to the residual, that's a different calculation than the total loss of all ownership and use of your property.
That's correct, Your Honor.
So you're not advocating that you would be entitled to the same amount of damages for the period of the MAP Act that you would be entitled to for the full take?
No, Your Honor. After all, hundreds of these people who were subject to the MAP Act continued living in their homes.
They continue to use the property.
Absolutely.
And if the property had been taken, they would have been required to vacate the property.
Certainly.
And there would have been an element of damages to that as well.
Yes, sir.
So that's what I'm trying to understand the relationship between the two. Even if we would say, if we agree with the state that the MAP Act implementation was the beginning of the take. You follow me so far? If we go with that line of thinking, then the amount of value that would be attributable will be less for those who did not have their property taken as opposed to those that did.
That's correct. And there certainly were people who were in that situation. One of our
Would
other
that apply
clients-
to a property owner who had MAP Act restrictions on some of their property that was not taken by transfer of title as well?
That's correct. And an example of that, Your Honor, one of our clients, Mr. Sanders, owned about several hundred acres in Fayetteville, and the DOT applied 2 MAP Act corridors to his property, and then they decided that they were not going to go the route of one of those corridors. And so he had all of that land, about 28 acres, that was never acquired by the DOT. This court considered his case and decided it in February and rejected every one of these decisions, every one of these arguments based on Kirby and Chappell that Mr. Rhodes is making today. What this court said in Sanders is we got to look at the U.S. Supreme Court's decisions in First English and Westinghouse because there was only only 2 things that the Kirby court could have done. It could have said there was these MAP Act regulations were an exercise of eminent domain and therefore a taking, and the property owners get paid, or they were an exercise of the police power, they were a regulation that didn't go too far, they were not a taking, and money doesn't get paid. Kirby said it's a taking.
So if the DOT had built a drain pipe and had dumped water on your property, and they came back and fixed it and stopped doing that, you agree that your damages going forward would be cut off when they stop dumping?
Absolutely. Absolutely, and
And that would be a temporary taking at that point?
most certainly. And we in this room, all of these folks from the AG's office who are here today, deal with temporary takings all the time, and the DOT values them in the form of temporary construction easements, temporary drainage easements.
And even full easements, perpetual easements too,
That's right.
that are different from the physical transfer of title to the property, because in the easement, the property would remain with the original owner.
And what the DOT could have done if they wanted to be able to make the argument that Mr. Rhodes is making, if they wanted to say that this was an indefinite easement, they could have called it that. Of course they didn't. They didn't call it any kind of easement. They claimed they weren't taking anything. But they could have said it was indefinite. They could have said it was permanent, but they didn't. Permanent is what Mr. Rhodes and the department want you to think that it is. But what the Supreme Court said in First English is that it's temporary. And it doesn't matter whether it was intended to be indefinite or permanent or interim at the outset. What happens is we base the duration on the facts that actually existed. And Kirby didn't say anything different. The issue of the duration of taking was not before Kirby, and it was before Chappell. But what the court did in Chappell was hold its nose and say, God, we really want to find a way to uphold this jury verdict, but this case was a mess at the trial court. And since the trial judge did apply the correct measure of damages, the same one that we say applies, before and after, we're going to let it slide that she said it's an easement that never expires. Because based on, as the court said, based on the evidence in that case, that would not have changed the jury's verdict. What the court said is, the question isn't whether that mischaracterization led to error, but the question is whether she correctly applied the correct measure of damages. That's all Chappell did. Chappell didn't say any of the things that the department is saying that it did about this not being a regulatory taking. And certainly, neither Chappell or Kirby said that the only standard for finding that there's a regulatory taking is a complete deprivation of all beneficial use. That's not the standard. There are 100 Supreme Court cases that say that's not the standard. That is a standard, but as the court said in Penn Central, you can have a physical taking, you can have one that deprives of all beneficial use, or you can have one that you decide whether it's a taking based on the situation-specific factual inquiry, and that's what the Court of Appeals said in Kirby. So if you just look at the Supreme Court opinion, you might not see that they're saying it's a regulatory taking. If you look at the Court of Appeals opinion, they clearly did.
So going back to an easement, in the general scheme of things, if a party is condemning an easement for water, sewer, or for a road easement, and they pay their landowner for that, and then they later come back and they take title to the property, either that same corridor or even more, a larger parcel. Can you cite an instance in where the condemning party would be entitled to a credit of what was paid for the prior easement?
I can't cite a case where, let me say it this way, it depends on whether the easement was temporary or permanent. If the DOT comes
Well,
along.
if it was permanent, that fact would reduce the value that would be owed for the take.
That's correct, because you would assume that the property was worth less because it was burdened by that prior permanent easement, but not if it was a temporary easement. And there's a case that's right on point. It's that City of Charlotte versus Spratt case, where there was a situation where there were overflights, and the overflights had ended before the direct taking came along to actually take some land for the runway. And the court said you have to look at the value before the taking for the runway as unencumbered, free and clear of that temporary taking. It's just like the example of the lease.
So a prior easement or a prior restriction would reduce value.
If it was still in existence on the date of the second taking, it certainly could.
So your case hinges on the fact that the repeal of the statute, the MAP Act statute, is what determined the fact the MAP Act restriction was temporary.
Absolutely. I'm not running from that. That's the facts. That is what the market would say. That's what the U.S. Supreme Court says.
So you came up here on a 108 order, I think that's the way they're commonly referred to.
Yes, sir.
And there has been, in your entire, that's a bench trial or a bench determination. And now you're wanting to go back to have a jury trial on damages, is that correct?
That's correct, Your Honor.
So, looking at the different views that you have from the DOT in helping the trial judge to instruct the jury on the measure of damages, what do you propose that would be? Because that's really what we're determining here.
To me, I do not think there is a disagreement about the measure of damages. The department keeps saying that we are asking for a different measure of damages, but we're not. We believe, and
Are you asking for the value of your client's property as unrestricted?
in the direct taking,
Yes.
yes.
And in addition to that, you're asking for damages for the 20 years that the property was restricted to.
That's correct. Those are two separate takings of separate property interests at different times. They don't overlap. There is no connection. They would not be tried together. Judge Collins denied the motion to consolidate them. The DOT has never asked that a MAP Act and direct case be consolidated before these.
Now, on prior cases before these two came up, how were they determined when property that was subject to a restriction, that all or portion of that restricted property was eventually taken? What's the difference in these cases versus the way it has been treated up to now?
There's not any difference in these, except that for some reason the DOT decided to put their foot down and say, I tell you the truth, I think it's because they're near the end of the MAP Act cases and they, want to litigate a couple more issues. Honestly, that's what I think. There's no difference between these two cases and every other MAP Act case that we have settled, and that's been dozens, if not 100. I don't know if any of you are familiar with Emmett Haywood. She's got an affidavit in the record. She's a very prominent eminent domain attorney, handled dozens of these MAP Act cases. She says she's never had the DOT take this position, that the MAP Act encumbrances continued to affect the direct takings. Judge Collins, the Rule 2.1 judge, says he's never seen that. There's no difference.
So this is, quote, new. This position is new.
Absolutely.
You're saying it's different and new from what prior cases have proceeded on.
It's different, and it's different than the position the DOT took in these direct cases. In these direct cases, the DOT alleged in its complaint that the MAP Act restrictions were not an encumbrance on the date of taking. In these cases, Mata and Wonder Day, Chapter 136-103 requires the DOT to state every encumbrance in its pleadings. It did not list the MAP Act. It did not appraise them as encumbered by the MAP Act. The federal regulations require them to consider all encumbrances. They did not consider the MAP Act. This is a new position that the DOT took since it filed this lawsuit, these lawsuits, direct ones, in 2020, and that's the reason that Judge Collins said they should be judicially stopped from taking this position. It's different than they have taken in thousands of other cases. And in the direct actions in these cases, which are not before you yet, but they're working their way up here, at least Wonder Day is. The DOT, for some reason, withdrew its motion in Mata. But in the direct cases, Judge Collins ruled on these same arguments because they were trying to say they got a credit for the 3 sticks out of the bundle. And Judge Collins said, that is not what you said when you filed your pleadings in this case or in any other case where property was formerly subject to the MAP Act. And I don't think this court has to go any further than that.
Judge Murphy?
Let me ask a couple questions just based on what we're hearing here. Is there anything in the record that indicates that the state, through its political subdivision of Wake County, ever charged a lower tax rate based on the loss of these 3 sticks?
The answer to that is...
The county taxes ever said, oh yeah, this property is not worth as much because you don't have these development rights and the like?
That's a great question. And yes, the properties that used to be subject to the MAP Act did get a tax break while the MAP Act was pending. When it was rescinded, the tax break went away. What better proof of the fact that the properties are no longer encumbered can you get than that? The evidence was removed from the public record.
I'll give you a moment to sum up.
What impact, if any, does our case law that says tax valuation at least serves as a floor in condemnation cases for valuation have on the extent of the taking analysis?
Hadn't really thought about that, and I think about tax value in the context of when somebody is, usually the department, trying to get it into evidence, and the general rule is that it's not admissible unless the property owner has manifested its agreement with that valuation. So I'm not sure that it has any applicability here.
I'll give you a moment to sum up.
Thank you, Your Honor. I guess in closing, I would say the United States Supreme Court decisions in First English and Westinghouse answer all of the questions that need to be answered here. Kirby is not inapposite. Chappell, the court just held its nose and just said harmless error. All Kirby said is there was a taking. First English and Westinghouse answer the question of what do we do when there was a taking, and we know at the time that valuation is set that the taking has been terminated. And what the court said in Westinghouse is when we're in that position that we're in here, we apply a judgment based on experience, not speculation. We don't apply a fiction that restrictions still exist when we all know they don't. Thank you.
Judge Hunter, you have any other questions?
No, Judge Tyson, thank you.
Thank you. Thank you. We'll reset the clock back to 5 minutes for rebuttal, if you would.
Thank you, Your Honor. The position that DOT takes here is involved in a petition for discretionary review before the Supreme Court, which has been supported by the law firm of Matthew Bryant that brought the Kirby case, the Chappell case, and the majority of the hundreds of MAP Act lawsuits that the department has settled. The idea that the position that the department is taking here is any different from the one that it has taken ever since the Supreme Court authoritatively established the law is simply false, and it has been the basis of negotiating settlements of just compensation in hundreds of cases with other law firms. What is going on here is an effort to obtain an entirely different measure of damages based on temporary easements. North Carolina law treats temporary easements differently than it does other kinds of easements, which are subject to the immediately before, immediately after standard. Temporary easements, like temporary construction easements, do receive something different. But temporary construction easements, all temporary easements, are different in kind because of how the Supreme Court of the United States explained the important part of the difference in the Kimball Laundry case in 1949. This is one of the cases that the landowners present to support their position. And that was one of the wartime cases where the Army took over a laundry facility on a one-year term that could be renewed for subsequent one-year periods for the duration of the war. And the Supreme Court there determined that based on those facts, rental value was appropriate. And in support of that position, the Supreme Court said the following: it was known from the outset that this taking was to be temporary, and determination of the value of temporary occupancy can be approached only on the supposition that free bargaining between petitioner and a hypothetical lessee of that temporary interest would have taken place in the usual framework of such negotiations. In all temporary easements, the court and any property appraiser must imagine the position of the parties on the date of taking as, in effect, negotiating a lease rate for the temporary period that they are agreeing to acquire property under. That's not the MAP Act. It applies to temporary construction easements. It applies to any easement that actually meets the factual description of First English, but not the MAP Act.
Let me ask you this, and just trying to understand, because I understand that precedent here may guide other cases. If we accept your position that the state would be entitled to a credit or to the value, would that not mean that the date of take would be from the implementation of the MAP Act, and that that full value that would be due would be subject to the 8% interest that Judge Collins would find then? And is that the really position the state wants to take if you're saying there's no difference in the value, in the damages? If that's true, then the operative taking would have occurred the minute the MAP Act was adopted. And the state would be liable for the damages for the entire time up until the take. I just want to make sure that, tell me I'm wrong.
That is not the position, Your Honor, but it is. So I will answer the question, but I just want to do it with the caveat that part of your question is not before this court yet for review, and it hasn't been prepared for review because it's actually the issue in a completely separate appeal. But your question is about the interrelation between the takings under the MAP Act and the subsequent direct condemnation. What the state is obliged to pay for under the Supreme Court's guidance is that they must pay on the date of the MAP Act taking for the taking of the right to improve, develop, and subdivide the property for an unlimited or indefinite period of time, plus 8% interest from the date of taking until the date of final judgment, and it must pay in the direct condemnation for the acquisition of the remaining rights that the landowner possesses, valued at the date of the direct condemnation.
And valued at highest and best use.
All of these takings ultimately are based on the highest and best use of the property on the date of taking. That's correct, Your Honor.
Could you see a scenario where that measure of damages could actually be more than a temporary take on property that's still owned by the owner as opposed to the value of the property thereafter?
What is absolutely clear, Your Honor, is that what the landowners are doing here by trying to get a rental value determination is that they are seeking compensation many multiples higher than has been paid to all prior MAP Act claimants under the Supreme Court's guidance. It is many multiples higher to pay rental value for a period of 20 years and then pay the landowner full fee value. This is not a matter of the department seeking a discount. This is a matter of paying fair compensation under the guidance of the Supreme Court and paying that compensation to all citizens who have been subject to this taking on the same terms.
Let me ask you this too. What's the position of the state on the duty of the property owner to have sought to stop the clock, you might say, in terms of asking for either the taking, the title to be transferred or the restrictions to be released? Is there a duty that the property owner owed that would stop the clock?
The Supreme Court answered that question definitively on the state's behalf. It doesn't matter if the landowner did it or not. What the state owes for a MAP Act taking is the acquisition of a negative easement on the date of taking.
And then
So-
the last question to your counsel's point, when you filed your position to take ownership, physical ownership,
Okay.
did you not assert that the property was unrestricted at that time in your pleading?
In the pleading, the department properly did not identify the MAP Act as an encumbrance in the section of those kind of form condemnation complaints identifying encumbrances. It is not being contested in any way that the 2016 legislative rescission didn't remove the encumbrance. The issue isn't the encumbrance, it's what the DOT must pay for. The landowner has one fee, one bundle of sticks, and DOT pays for the bundle of sticks once. If they pay for 3 of those sticks, the rights to improve, develop, and subdivide, plus interest in an inverse condemnation case, they only pay for the remainder of the landowner's one fee in the second condemnation case. It's not a discount. The landowner receives interest on the MAP Act taking, and as the Supreme Court of this state determined long ago in Leah Company versus NCDOT, which is in the pleading, it is through interest that the state compensates landowners for the time value of a taking. And landowners subject to MAP Act takings get a statutory rate unless they rebut it with a higher rate. But they get a statutory rate. Then the DOT pays for the remaining sticks at the 2020 values or 2019 values whenever the state steps in to require the remaining sticks. They acquire those at the present day values on the date of taking when that direct condemnation is filed.
Is there any dispute? Judge Collins found that the judgment rate was 8%. Is there any dispute on that?
That was the statutory rate at the time. No dispute at all.
Thank you. Any other questions? Judge Hunter, you have other questions?
I do not. Thank you, Judge Tyson.
You want to take a moment just to give us a brief, very brief summary. What relief would you ask us to do?
Your Honor, uphold the law as established by the Supreme Court of this state in 2 opinions. That's all. Uphold the law as the Supreme Court has laid it down. That has been the basis of hundreds of suits. There is no basis in law or equity to award these landowners a different way of valuing their claim. The law is clear, and the department would ask this court to uphold it.
Thank you.
Thank you, Your Honor.
Thank you both for your arguments. We appreciate it. Madam Clerk, will you adjourn court?
All rise. My pleasure. Absolutely. This Court of Appeals session is adjourned.